20 years ago, a Republican governor signed a bill into law that permanently banned AR-15s. That Republican was Mitt Romney, who would later win the Republican nomination for president and currently serves in the U.S. Senate today. So don't ever tell yourself the lie that you are voting pro-gun just because you're voting Republican. If you want to vote pro-gun, you must examine each and every candidate's records and stance on guns, regardless of political party. It's when voters fail to do this that gun control measures like so-called assault weapons bans become the law of the land. And today we are still trying to undo the damage Mitt Romney did as governor to the inalienable rights of the people of Massachusetts.
We do have tough gun laws in Massachusetts. I support them. I won't chip away at them. I believe they help protect us and provide for our safety.
I trusted you, and you gave me this!
But before I get into how we're doing that, I'd like to ask you to take a moment, please, to like this video and subscribe to our channel. That will help ensure both that you get the latest gun rights news as we get it up, and it will also help us to reach more like-minded people on YouTube. Romney signed the permanent state assault weapons ban back in 2004, but it wasn't until the summer of 2022 that your National Association for Gun Rights was able to file a lawsuit to overturn the Romney gun ban. So you may ask, why did it take us so long? Well, there are two reasons. Number one, the primary way you stop bad policy from passing or you overturn bad laws is in the legislature. The reason your state lawmakers do so many bad things, from gun control to spending to taxation, is because the people who care about those issues fail to mobilize effectively and hold their lawmakers accountable for every bad vote. That is what the National Association for Gun Rights was created to do, to go into state after state after state and mobilize and empower the grassroots to force lawmakers to uphold the Second Amendment or be replaced in the next election. And we've done that, which is why we now have 27 constitutional carry states where the Second Amendment is your carry permit. And we hope to get a couple of more states this year. The second reason we had to wait so long to challenge the Romney gun ban is because for years, the lower courts trampled the Second Amendment by using a two-part test for every gun case that landed on their dockets. Basically, this means they'd run a cost-benefit analysis weighing the supposed benefit of the gun control law against the value of the Bill of Rights guarantee. It was just lawyer speak for, we don't like gun rights and we don't care what the Constitution says. But that is the way the courts were ruling for years. All of that changed in 2022 when the Supreme Court ruled in New York State Rifle and Pistol Association versus Bruin. That ruling told lower courts in no uncertain terms that they were no longer allowed to run those cost-benefit analyses on gun rights, and instead, they had to rule on the text, history, and tradition of the Second Amendment. As a result, we immediately went on offense. We filed 7 lawsuits all across the country, challenging AR-15 bans and standard capacity magazine bans, including in Massachusetts. The goal was to get the issue back to the Supreme Court as quickly as possible, in order to hopefully get a nationwide precedent striking down assault weapons bans once and for all. And by the way, we are about to ask for that nationwide precedent in our Illinois gun ban case, and we will be giving you more updates on that here on YouTube very shortly. So, though, back to the Romney gun ban. We filed a lawsuit challenging that in federal district court in Massachusetts, and we asked for a preliminary injunction to block the gun ban's enforcement throughout the duration of the lawsuit. And we waited on a ruling for months. Well, we finally got that ruling 4 days before Christmas, and the judge went full Grinch mode on the Second Amendment. Now, we had an inkling that was coming because during oral arguments, the judge compared our interpretation of the Second Amendment, which is really the founders' interpretation, to a suicide pact. But we didn't expect him to pull a Grinch move and drop an anti-Second Amendment ruling on us literally right before Christmas.
Hate, 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 double hate, loathe entirely.
And get this, the judge was appointed by another Republican, President George W. Bush. So thanks a lot for that, Mr. President.
Our enemies are innovative and resourceful, and so are we. They never stop thinking about new ways to harm our country and our people, and neither do we.
Now, this ruling was a little different from some of the other anti-gun rulings we've gotten in places like Illinois and Connecticut and the Seventh Circuit. Those were egregiously bad rulings that made outrageous claims like AR-15s aren't actually guns as far as the Second Amendment is concerned. Judge Saylor's ruling in the Massachusetts case is a little different because he gives more lip service to Bruen, and the loopholes he uses to bypass the Second Amendment are a little bit more subtle. But the conclusions are just as outrageous, and they have the exact same effect of upholding an unconstitutional gun ban in defiance of the Supreme Court's precedents. For instance, Judge Saylor uses the Supreme Court's finding in D.C. versus Heller that handguns are the quintessential self-defense weapon to conclude that this means, quote, legislatures have some greater degree of latitude when regulating firearms that are not handguns. In other words, yes, Heller said you can't ban handguns, but we can do whatever we want to rifles. So basically what he's doing is limiting Heller's applicability only to the actual facts of the Heller case. And no lawyer or judge who's acting in good faith is going to think for a moment that Heller doesn't apply beyond the handguns at issue in the case. In fact, that's exactly what legal case law and precedent is all about. But Judge Saylor said that, and he went on to claim that if the handgun is, quote, the quintessential self-defense weapon, firearms with features not found on a handgun, such as AR-15s, are not as useful for self-defense. Here is his exact wording on that. If a handgun has features that make it more suitable for self-defense, it follows that other firearms may have features, including not only capabilities, but also size, length, and weight, that make them less suitable for that purpose. And then he went on to conclude later in the ruling that, quote, the firepower of an AR-15 also contributes to making it generally unsuitable for self-defense. Now that's just outrageous, because I know I speak for many of you when I say that I own an AR-15, and I own it for self-defense. But the other reason that's outrageous is because government doesn't get to make suitability judgments on the weapons Americans choose for self-defense. And in fact, that is exactly what Heller said in the very passage that Judge Saylor was cherry-picking. Here is that full quote from Heller. It is enough to note, as we have observed, that the American people have considered the handgun to be the quintessential self-defense weapon. There are many reasons that a citizen may prefer a handgun for home defense. It is easier to store in a location that is readily accessible in an emergency. It cannot be easily redirected or wrestled away by an attacker. It is easier to use for those without the upper body strength to lift and aim a long gun. It can be pointed at a burglar with one hand while the other dials the police. Whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid. In other words, judges may speculate on why a weapon is in common use for self-defense, but it is the people's choice and not the role of judges to second-guess their decisions. Now, judges like Judge Saylor really like making those suitability determinations, because if they actually obeyed Heller, that would mean they couldn't ban guns that are in common use for lawful purposes. And politicians in all branches of government, judges included, hate being told they're not allowed to control things like that. But under the Second Amendment, they can't. And that is why we're appealing this ruling. But before I get into that, I wanted to take a moment to share with you the exciting giveaway we have going on right now. Trust me, you're not going to want to miss this one. So, what is next in the Massachusetts gun ban lawsuit? Well, we are appealing to the First Circuit Court of Appeals to get this ruling overturned as quickly as possible. Our attorney, Barry Arrington, has already begun the process of filing that appeal, and pretty soon we'll be filing our opening brief explaining in detail all the ways Judge Saylor's ruling got it wrong. So stay tuned for details on that very soon. This is only one of multiple legal battles we'll be coming to you with updates on, and every single one of these battles takes resources. So I would ask you to please join with us in the fight today for the Second Amendment by making a generous donation to our legal war chest in the link below. Our lawsuits are literally funded by the generous supporters of gun rights all across the United States. And if you're one of those supporters, thank you for making this work possible. And if you're not, we'd ask you to please consider joining us today. And also, don't forget to like this video and subscribe to our channel for more updates. And until next time, thank you for watching.